call to order the meeting of the Davidson County Election Commission, April 22nd, 2024 at noon. This is a special called meeting, and we are waiting for one of our number, but we will go through some other matters while we wait for him. The first item on our agenda is public comments. Does anybody from the public want to make comment? We do. The chair recognizes Jim.
And good afternoon to you all. Trish, it's good seeing you, and I don't think I've ever seen you with your hair quite like that. Almost didn't recognize you.
Nice to see you too.
You guys have got an important job to do today, and on the 2nd, these signatures that these candidates are getting are very critical. We try to impress them with the idea of getting more than 26 signatures or whatever they do. I like to see when they get 60 and 70 signatures and Kelly can stop counting when she reaches 25 that she's comfortable with it and has a good background. So you guys have got an important job to do today. We would appreciate, I know that everyone would appreciate the fact that you're going to give this a lot of thought and due diligence, and we do appreciate that on your part. I thank you guys all for the job that you do here in this county. This county is, in my opinion, one of the best run election processes in the state. Now, truthfully, I've not visited all 95 counties, but I have visited quite a few and have talked to my counterparts in other counties and listened to their complaints. And I've been working with you as an officer of elections since about 2010, so I've got some experience knowing the transitions you guys have done. And I think Davidson County is one of the best ran in this state, and I do appreciate that. Thank you guys for the job that you do.
Thank you, Mr. Garrett. Is there any other public comment? That will take us to item 2 on the agenda, and that is to consider the minutes from our last meeting, March 19th, 2024. Those are in our packets, and we've received them in advance. Commission members, when you've had a chance to review those and either have comments or a motion, just please let us know. It appears we're ready for a motion.
Mr. Chairman, I'd move to approve.
We have a motion. Do we have a second?
Mr. Chairman, I'll second.
With a motion and a second, all in favor say aye.
Aye.
Aye. Any opposition? With no opposition, the motion carries. So we've gone through public comments and the minutes from our last meeting. And at this time, I'd like to go down in the agenda to item number 6 and discuss our next meeting date. I think we have actually 2 meeting dates that we've considered. And at this time, we'd like to discuss those. Mr. Roberts, if you could explain the next 2 meeting dates that we're about to consider.
Mr. Chairman, you've already set the May 3rd date at 3 o'clock with the main item on the agenda will be to set the ballot at that point.
Right.
We ask or recommend that you consider a May 2nd at 6 p.m. date to have the hearing for the signature challenge. And I recognize the 6 p.m. is a little different, but we wanted to make sure that the public and the challenger and the candidates could have it set at a time when they could participate in as much as possible.
So we have two challenges, and we're to consider both of those challenges at that time.
Yes, sir.
All right. And can you announce for us what those two challenges are?
We have a challenge from Laura Nelson against the signatures collected by Justin Jones. We have a challenge from Representative Mitchell, Bo Mitchell, challenging the signatures collected by Jennifer Frensley Webb.
Okay. All right. Okay. All right. So then do we have a motion to set our next meeting to discuss those two challenges and decide on those two challenges on May 2nd at 6 o'clock?
I'll move.
We have a motion. Do we have a second?
I'll second.
We have a motion and a second. All in favor say aye. Aye.
Aye.
Any opposition? With no opposition, the motion carries.
Mr. Chairman,
Yes,
before you
sir.
move, let me express my appreciation to the commission for today's meeting on short notice, getting all five of you together and the Metro M&N folks here to be able to stream this. It's a big task, so I appreciate all your effort in helping us deal with this short notice so that we can move on to the May 3rd meeting.
All right. Thank you. That will bring us back up to item 3 on the agenda, and that is to set a protocol for our next meeting, and hopefully a protocol at least as a template to use in other similar type issues that might arise in the future. In our packets, we have item number 3, which is standard rules of order for candidate signature challenges. And as I understand that, this is based on similar issues that we've had in the past, although it's not identical because we have not had issues just like this arising before. So this is based on matters that we've had that are similar to this one.
That's correct, Mr. Chairman. In the past, you've dealt mostly with residency challenges, and this is a little bit different in that the challenger is challenging a signature collected by a candidate. So included in your packet, number 3 is an outline of how the meeting would be conducted on May 2nd to make sure that we give ample opportunity for both parties to present their information before you so that you can make an informed decision. The second page stapled to that gives you an idea of the outline that we've created here so that we create the expectation of when you will have information from the candidates so that you can prepare for the May 2nd meeting. And we did this so that you would have the information and specifically to provide 2 opportunities for the challenger and the candidate to provide their initial information to us and then have an opportunity to supplement that a couple of days later once they see what the other party is going to do. So we're trying to be as fair as we can be and allow both parties an opportunity to put forth before you as much information to make their argument as possible.
Mr. Chairman?
Yes, the chair recognizes Commissioner Hertzfeld.
I agree with this draft standard rules of order. It seems to mirror exactly what we've done, pretty close to exactly what we've done in residency petitions. So that seems appropriate to me. I just have one point of clarification. At the bottom, it says discussion by commission members. And my assumption is that after we have the presentation from both parties, that we would vote to determine ultimately whether we think the signatures work or not on that at that same meeting, and not wait until the setting the ballot meeting the next day. Is that right?
That's at least my understanding. There would be discussion and then a vote.
Okay. We just want to probably make sure when we notice the meeting that we indicate that we intend to vote. So
Right.
it's just clear.
Sure. So your suggestion, I don't know if it needs to be a suggestion or a motion at this point, would be to say discussion and vote by commission members.
I think that's probably like the
Right.
rounds it out.
Mm-hmm.
Other than that, I think this is great. I really appreciate the fact that we have all these dates on the back to kind of get evidence in an orderly way so we can be prepared and not just having stuff slung at us in the middle of a meeting. So
Right.
I appreciate the hard work of the commission and Mr. Roberts on that.
Mr. Chairman?
Yes. Yes, sir.
Just a quick point of clarification. I agree with what the Commissioner said about this. I think it's good. Just a question. Have we done this in consultation with Metro Legal and or the coordinator's office?
Yes, Mr. Roberts, why don't you explain that?
I've coordinated both with Metro Legal and the coordinator's office to make sure. In fact, the last statement on there was a quote from the coordinator's office to make sure we had that in there so that they could participate.
Very good. Thank you.
Right. And I would like to express my appreciation and commendation to both Metro Legal and the state coordinator's office, because as I understand it, they have sat down and conferred jointly on a lot of these issues, and the advice that we're receiving and the guidance we're receiving is coming from both of them after they've conferred, which I greatly appreciate.
I also see that we have an affidavit, a draft affidavit in our packet. And I just want to be clear that people could submit affidavits, but that does not preclude them from bringing witnesses live. Is that right?
I mean, I don't know if that's addressed to me, but it was my understanding that as part of the advice we received from the state coordinator's office and from Metro Legal, that affidavits would be accepted. And I believe that Metro Legal prepared a draft affidavit for the challenger and candidate to use.
It's just a format of an affidavit.
Right.
Yeah.
Yes. It's not to say some other form might not be acceptable, but in order to try to help the people presenting evidence,
it's for the commission to approve this format as something that can be used. Like you said, if someone presents another format that complies with the law, that's fine too.
I make a motion to approve.
And so it's clear we're moving to approve then the two-page standard rules of order for a candidate signature challenge and the form affidavit as a form that is acceptable for use, although not necessarily the only form that would be acceptable.
Yes, that's the motion.
All right, we have a motion. Is there a second?
Second.
So we have a motion by Commissioner Hertzfeld and a second by Commissioner Davis. All in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries. I do have a question. Mr. Roberts, do we have a plan to provide what we've just voted on to the candidates and the challenger? And if so, how are we going to do that?
Both parties have already been provided a draft. So after today's meeting, I will follow up with them and tell them it's a final version. So because of the short time frame, I've tried to keep both parties as informed as I could as we've been moving along down this direction so that they can prepare. If you'll notice on the timeline, they have until this Wednesday to get their first set of documents back to me so that I can share with both parties and you. So we're on a very tight timeline here.
Right.
And if everyone sticks to that, I think we can make this happen very orderly.
Okay. All right. There's another issue that has arisen, as I understand it. Mr. Roberts, can you explain to us briefly the issue about Ms. Nelson and what I understand is her request to appear via Zoom or video or some other way on the May 2nd meeting?
Ms. Nelson notified me that she was going to be out of town on the 2nd and asked if we could do it on one of the other dates that were initially proposed. As all of you know, the 2nd was really the only date that we could get all 5 of you together. We're also having to work with when we could get the Howard office building to televise. So everything is logistically very challenged, and May 2nd was the only date. I think the alternative might be if we can, for the candidate or challenger, set up an opportunity for them to make a statement, either via phone call or some other form of technology at the hearing.
Okay. And as I understand it, you've checked on this issue with Metro Legal. The commissioners cannot call in, so the question then becomes, can a challenger in this case call in, and it only is going to apply to the challenger, not to witnesses and other things like that, because the putting a witness on would be...
I would say you open it for the challenger and the candidate that is being challenged, so that you've covered both parties the same. But I think I don't know that we can logistically pull off if we've got, 12 witnesses and whatever, make that happen. So that's what we're concerned about.
So that's the question before the commission, and I just open it up for discussion to get everyone's views on that point. It just came up this morning, as I understand it.
So, if I may.
Yes. Commissioner Hertzfeld is recognized.
My gut reaction on that is not a positive one. I'm happy to have it open for discussion, but the commissioners have to be here in person. I would certainly feel incredibly strongly that, especially on an issue of legitimacy of signatures, that the witnesses be here in person. I think there's a lot of benefit from looking at a person, judging their demeanor, watching how it is that they respond. And I appreciate the fact that technology has brought us a long way, but as a person who's taken a lot of Zoom depositions, I just don't find them to be nearly as enlightening for things that have to do with credibility as having a person physically in front of you. I understand there's a little bit of a difference with the challenger and the candidate if they're not witnesses, but I would suspect there would also be a time we may want to put them under oath as to how it is that they gathered the signatures. And I just, quite frankly, I'm not feeling, if this is your election and you're trying to run for office, I think you should be here to defend it. So I'm open to having my mind changed, but my initial gut is if this is important enough to you to to be on the ballot, that you need to be here personally. Everybody else has to be here, and the candidate and the challenger should be as well.
So I'm questioning out of point of order because so the state and Metro Legal said it would be legal for her to do so, or is that just, so the question is it illegal, or is this just a suggestion, or what in regards to her wanting to Zoom? Because I know previously, that we, as commissioners, we couldn't do that.
That's correct.
So to Commissioner Hertzfeld's point, I'm like, so that we have to be in person with not the candidate.
Yes, Ms. Ecke, it looked like you've got something to say, and we'd like to hear from you.
Well, I just want to say, with regards to you having to be here, that is required by state law, in that commissioners need to be in attendance in person. So that's a different issue. The issue becomes, ultimately, you have the final say. One, by approving this format of affidavit, that kind of infers that you are permitting people to submit, including witnesses, information via affidavit and testimony. Is that correct? Because that's what you're doing by saying, this is a testimony by somebody. So I just want that clarification that you're already appear to be permitting some testimony by affidavit.
And that was based on the guidance from the state coordinator's office and from Metro Legal,
Well,
by the way. But yes, I think we are permitting information to be provided to us that's not necessarily in person.
But
Yes.
if I may,
Yes.
I do think
Yes.
there's a significant difference, and when we are looking at it, we'll be weighing various things. So we can weigh what's in the affidavit versus weighing who's come in person versus weighing their credibility and the people that are in front of us. So I think it just goes to, a weight of the testimony. I'd prefer to have every witness here in person, in case anybody's watching. I'd prefer to have everybody here in person. If the candidates choose to, have somebody who signed a signature, say they've got to work or whatever, do an affidavit, we'll be able to weigh that evidence and how much we want to be able to use that. But specifically for the candidates and the challengers, I just think it's important. I think it's important that they be here in person.
Any other? Yes, Commissioner Starling.
Mr. Chairman, there's something to being in person, as Commissioner Hertzfeld stated, as well as Commissioner Davis. I think we may be opening up an area where, after a while, nobody will come. They'll just submit it in writing or be on video. So we need to be careful when we are doing this, because we're doing something that will allow another issue come up. I can't make it, and let's just do it by Zoom. So I think we need to be careful. We may need some guidance somewhere else down the line from Metro Legal or from the state as well. But, I'm concerned, as Commissioner Hertzfeld has stated, that I would like to see people in person. That's me as Commissioner speaking.
Mr. Chairman? I agree. I'd love everybody to be here in person. I think that's good. But I think the point is, yes, as Commissioner Hertzfeld said, we will need to evaluate based on what we hear and who says what, and you may give some inference to the fact that they're here or not here, and you've got to balance that. And I get that, but that doesn't change the fact that it's appropriate that it be done via Zoom. If we're going to have somebody submit an affidavit, yeah, absolutely. I've got to judge that, but it is what it is on its face. And if somebody needs to come in via Zoom, and Metro Legal has indicated that that's not a legal problem, then I don't see that we should prevent that person from doing that. Yes, I would wish they would hear in person, absolutely. But I don't think that's, and as to Commissioner Starling's point, I'd hate for us to get down the line where we're consistently talking to people versus Zoom and so on and so forth. But again, the bottom line is it meets the legal standards. They have to determine how important it is for them to be here as opposed to their statement being observed and weighed by virtue of Zoom. But I don't think we need to prohibit that. I would suggest that we would allow that.
Mr. Chairman, just a point of information for you. You know, in the residency challenges that we've experienced in the past, it has not been unusual for the challenger or the candidate to have their attorney or another person speak on their behalf, both to introduce as far as the opening or the presentation of facts. So I just wanted to remind everyone that that's typically what we've seen in the past for some of those residency challenges.
Any other comments? Mr. Davis, you're recognized.
So, two things. Well, I think on the residency, even with the lawyers, I do believe, as long as I've been on the commission, the person who was challenging or whatnot was here, though. Correct? And I'm asking. So also, since it's not legal, legal issue per se, so this sounds like, and I'm addressing more to Mr. Roberts and of course the commissioner. So basically, if whatever we decide, we're setting precedent more than anything else, which is basically our purview anyway to this case. Correct?
Yes, okay. Especially as we get into the witnesses that might be,
right,
brought forward. It becomes a bigger challenge if you've got multiple people that we're having to connect through Zoom or phone call or whatever, as opposed to a single person.
Mm-hmm. Okay, thank you.
This is Commissioner Delanis speaking. There is some precedent for having people on the telephone in that we have had the state coordinator's office speak to us over the telephone before. So that's one factor to weigh. Another factor to weigh would be what if we had 2 or 3 challengers or even a candidate say they can't be here. Would we be able to accommodate, let's say, 3 or 4 people? Could we do something like that if we opened this up, in this case, to Ms. Nelson?
Well, Ms. Nelson is a candidate.
Right, I know, but let's
you're
say,
talking about an additional candidate.
Right. Let's say we had candidates and challengers of, let's say, 2 or 3 or maybe even 4. Could we accommodate that if we created this precedent?
I think anything's possible. It just becomes more of a logistical challenge for us to get set up in a way that it would be useful. I mean,
right.
It's just more difficult the more people that we have having to connect to over phone, and,
All right.
What happens if the connection goes bad and we lose them? We do have the issue that we'll have to check on at Howard, that the cell service is not good.
Okay.
Because we're below ground.
All right. Another factor that I think we at least should consider is that Ms. Nelson this would apply both to a candidate who's being challenged, and someone who's challenging her. And I certainly could see a situation where a candidate gets a challenge and he or she literally cannot be here, maybe a death in the family, maybe something, something really, really important, we would be setting a precedent, basically saying, no, we're not even going to consider it. And, I think part of what we want to do is encourage people to run for office too. And let's say you did your best work to put your petition together, and notwithstanding that, you got a challenge, and you couldn't come to the hearing, and yet your candidacy is going to be judged without even having a chance to speak, because what we're talking about here is a 5-minute opening statement. So those are just the other factors. Everybody's raised good points here, no question. Your first reaction is, hey, wait a minute. If I have to be here as a commissioner, surely the candidates have to be here too. That's certainly an important point. But on the other hand, we want to encourage people to run for office. I'm sorry, Commissioner Hertzfeld, I know you've been wanting to say something.
I don't think we have to open everything completely up one way or the other, right? I think the issue here is, right, to be very clear, whether the candidate or the person doing the challenge must be here in person. And I think we may be looking at it a little bit askew. I think you can have a person come and represent you in making your argument, and a person can come here and represent you. You don't necessarily have to be here, right, in order for a lawyer or whoever to make that argument on your behalf or to defend you or, whatever. I think you should be there. But, that's a question, I think, for each candidate or challenger to decide. But I think the more narrow question we have is before us whether the challenger or candidate can appear by Zoom or by telephone in order to take testimony or make their case. And I think the logistics of trying to conduct a half in person, mostly in person, not in person, hearing, whatever it is we call this, presentation opportunity is very difficult. I'm not saying that doesn't mean someone can't send someone in their place, to do that. But I do not think we should have the candidate or the challenger appearing via remote stuff. And I think that kind of addresses your concern of, what if you're on the ballot and somebody just challenges you and you've had a death in the family and you can't make it? That person could have someone come in their stead if that was necessary.
Let me ask AOE Roberts a question. Is this request just to make an opening statement as opposed to participating generally and asking questions and closing statement and all those types of things, or is it just a 5-minute opening statement?
In the communication this morning, I did not get, specifically at what level of participation Ms. Nelson was going to attend. So I can't say whether or not it was just for the opening statement or the closing statement or either. Another option that the commission might want to consider would be a recorded opening statement that could just be played if you felt like you needed as a candidate to make one and you weren't going to be here.
Mr. Chairman.
Yes, Commissioner Hertzfeld.
I think if the candidate can't make it, the candidate should have someone come and make the presentation for them. I think those are kind of your options. I mean, that way they're not being denied due process. They're not being denied the opportunity to present their challenge or whatever argument it is. But somebody needs to be here to make the opening statement. Somebody needs to be here to look at the evidence, to listen to the questions, to, do all those things if they want to, continue with their challenge. If you're taking the burden on to make the challenge, I think you have an obligation to be here to make that challenge. And if you yourself, you as the person making the challenge can't be here, you have an obligation to get somebody else to speak for you to make that challenge. But I think there's also, I mean, we haven't seen the proof or anything that's in the record. So, you know, I don't know if it's going to be sufficient if that person's not here, but I'm assuming that they, you know, they have some burden to make. And, you know, if that person is here, they can make that burden. I think it's very difficult for you to be the challenger of the sufficiency of someone else's petition and not be here to do that. I just don't really understand how we could set that precedent. Otherwise, I'm worried people just do stuff and then be like, okay, I'll just zoom in and, you know, we'll figure it out. It causes me some pretty significant concerns for, you know, procedures moving forward. Now, if there's someone speaking on, you know, her or their behalf or, you know, whatever, they've hired a lawyer in order to do that or, you know, whatever, I think that's perhaps a different story. But I do think the person who has made the challenge does have certain obligations, you know, to at least clear a burden and how that can be done and what that's based on. I think it's dangerous for the person making the challenge, you know, not to show up themselves. But I don't know what evidence there is, so it's difficult for me to get into the specifics. But generally, those are my thoughts.
I have another question. Mr. Roberts, do we know whether or not Ms. Nelson was available to come to this meeting and make this request in person?
I do not.
Okay, but well, we know she's not here.
Correct.
Okay. All right. Any other discussion?
Mr. Chairman, yeah, I mean, like I said, I don't want to beat dead horse, and I try not to repeat myself, but yeah, absolutely, the candidate, the challenger, has the burden to prove themselves, prove their case, but that's our decision. And we've got to weigh whatever they say in whatever format they say, you know, according to the sense that we get from what they're saying. I don't. Again, I think if Ms. Nelson wants to make her 5-minute presentation via Zoom, if we've got the technology to do it, I don't understand why we don't do it. Now, I think it's a different issue if she's going to try and do some sort of back and forth via Zoom. I think that's a bit problematic that I'm not sure we want to get into. But for the sake of making an opening and closing statement, you know, I don't see what the issue is, respectfully.
Now, if she makes an opening and makes a closing, she will probably want to listen to everything that's said, right? And we've got the capability to do that.
Currently, we are planning for the meeting to be televised, but the going back and forth, that's where the issue
Right.
comes
No,
in.
I don't think we even have that before us, whether or not she's going to want to participate and ask questions. I don't think that's completely impractical. I don't, as I construe what you're telling us, I don't even think we're being asked to do that. What I think I'm hearing is that she's asked to make an opening statement, and that now Commissioner Burns, I believe, has raised the issue of whether or not she should make a closing statement also. And it seems to me the next logical question is, if she makes a closing, it would have to be based on something that happened here before us. So she's really, we can construe her request, I suppose, however we like, but it sounds like she only asked for an opening statement. Then
Let me
is that
clarify,
right?
Mr. Chairman. She asked that we change the date of the meeting. She didn't
Right.
ask for a Zoom or a phone-in or just say the opening. She asked for none of that. She asked to change the date of the meeting.
All right, and you informed her we couldn't do that, did she at that point ask to be on Zoom?
I have not informed her either way. My first communication was with Metro Legal as to whether or not there was an option
Okay.
if she couldn't be here.
So has she even asked?
She is not asked
Okay,
to participate
all right.
by phone or by Zoom
Okay,
or
all right.
anything else.
Okay, all right. Well, I'm not sure it's really quite before us at this point. Now, she might make that request, and we might have to take it up at the, at the May 2nd meeting on the fly. But I don't. As chair, I don't think we've got anything properly before us at this point. We're not going to change. We can't change the date of the meeting. So unless someone objects, I say let's go on to the next item. Okay. All right.
So question.
Yes, sir.
So I know we were in the middle of, so do we need to have a call? We need to have a vote on that? Because I think, do we have?
Do you want to vote on that?
No, I'm talking about, we're in the middle of approving the, do we make?
I think
we approve those?
we've
Okay.
already approved.
We got into the weeds.
Yes,
I was like, did we
have,
approve that?
Yeah, we did. We
Okay,
did.
double checking.
We
I
did
was like,
approve that.
okay.
Yes.
Checked it off.
Yes. So the next item then is item 4 on the agenda, state guidance document verifying petition signatures. And I believe we've got that in our packet. Mr. Roberts, if you could just explain what item 4 in the packet is.
Commissioners, item 4 is the guidance we received from the state on how to verify petitions. This has been used for a number of years, and it's pretty specific as to how we are to make a judgment call on a signature, because we have electronic signatures and people signing their everyday signature and their official signature. There are a lot of different signature forms, so the state has been pretty clear on the guidance that they provided. I thought it was important that we add this document to the record, that everyone knows how we are supposed to consider signatures on petitions.
Okay.
So really just looking for you to add this to the record.
I make a motion to add it to the record.
Do we have a second?
Second.
We have a motion and a second. All in favor say aye.
Aye.
Aye. Any opposition? With no opposition, the motion carries. And then looking back to the motion that we granted under item 3 on the agenda, will that be attached to these minutes as part of the record also, Mr. Roberts, so that everyone will be able to find it if they need it?
Yes, we will attach that.
All right, okay. All right, then item number 5 is the AOE report. Mr. Roberts, can you give us that?
Commissioners, for this meeting, I'm going to limit my AOE report to just going over the timeline that is on the back of your document number 3, just so that you are aware of the things that will happen in front of us. So April 24th at noon, that's the first opportunity for the candidates and the challenger to provide to us their evidence for the signatures that have been challenged, and for them to provide any witnesses that they plan to bring forward. I'll share that with you and with both parties. Then they have 2 days to come back and offer additional or supplemental evidence and witnesses. So trying to provide them as much opportunity as possible to get before you the things that they plan to share, so that we're not overwhelmed on the 2nd with new stuff coming in. So that's the plan. And then May 3rd, after you vote on May 2nd, that's when we would set the ballot for August.
I think that sounds great.
Good. Commissioners, any questions, comments? All right. Anything else on the agenda?
Motion to adjourn.
All right. We have a motion. Do we have a second?
You have a second.
All right. All in favor say aye.
Aye.
Aye. Any opposition? With no opposition, the motion carries. Thank you, and we will see you back here on May 2nd. Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.